and I'd like to recognize myself for 5 minutes for an opening statement. We welcome each of our witnesses and appreciate your willingness to be here today to talk about the final coal ash rule released by EPA in December. We are eager to hear from the administration. We hope Mr. Stanislaus will be able to provide some clarification about the implementation of the final rule and also answer some questions and address some concerns. We will hear from a number of stakeholders regarding their initial impressions of the final rule and any concerns they may have, and we will also discuss the final rule in comparison to the legislation we considered through this committee and to the floor of the House the last couple Congresses. First, I would like to commend the EPA for getting the final rule out in time to meet the court-ordered deadline, weighing in at over 700 pages. I'm sure that that was no small undertaking. I would also like to acknowledge that in finalizing the rule, the agency faced a genuine dilemma: create an enforceable permit program for coal ash under Subtitle C and designate coal ash as a hazard waste, or promulgate a self-implementing standards for managing coal ash as non-hazardous waste under Subtitle D. I am pleased to note that EPA chose to regulate coal ash under Subtitle D, which will help ensure that coal ash continues to be beneficially reused like this. However, because of the way Subtitle D is currently drafted, EPA did not have the authority it needed to create a permit program for coal ash. Instead, the final rule lays out an entirely self-implementing program that will be enforced through citizen suits and will unavoidably lead to an unpredictable array of regulatory interpretations as judges throughout the country are forced to make extremely technical compliance decisions that would be better left to a regulatory agency. The final rule also sets up a dual regulatory program. EPA strongly encourages, and I quote, that for states to incorporate the requirements into their solid waste management plans. However, as currently drafted, RCRA does not allow state coal ash programs to operate in lieu of the federal requirements in the final rule, meaning even if states adopt the federal requirements or requirements that are more stringent, the federal requirements remain in place and utilities must comply with both the state and federal requirements. There are some other provisions in the rule that are potentially troublesome and that we hope to discuss today, including the retroactive application of location or siting restrictions and the requirement that unlined impoundments that exceed a groundwater protection standard close with no opportunity to remedy the problem through corrective action. Last but not least, EPA has removed the flexibility of the correction action program as it exists for other programs under Subtitle D. It is understandable that the agency may feel the need to tighten certain restrictions because the rule is self-implementing. However, by removing flexibility regarding the boundary within with which compliance must be demonstrated and flexibility to determine the appropriate cleanup levels and eliminating costs as a factor that can be considered in completing corrective action, the final rule jeopardizes the future of risk-based cleanup decisions at coal ash disposal units. The removal of this flexibility also creates uncertainty with respect to ongoing cleanups at coal ash disposal facilities. While we acknowledge the amount of time and effort EPA put into drafting the final rule, because of the significant limitations of the rule, we still believe that a legislative solution might be required that would set minimum federal standards and allow states to develop enforceable permit programs to implement the standards, which we think could still be the best approach in dealing with coal ash. I can assure you that we intend to be thoughtful with respect to the requirements in the final rule and how they differ from the legislation that we moved through this committee and the House during the last Congress, and we will update the legislation as necessary. As Mr. Stanislaus pointed out when he spoke with us last time, there are some important issues that our previous bills did not address, in particular regulation of inactive impoundments. We will address these units as we move forward. I would like to thank the administration for all the cooperation we have received to date on this issue. EPA has been constructive and helpful both with our legislative efforts during the last Congress and recently as we work through the issues with the final rule. We appreciate all our witnesses for being here. I would also thank Mr. McKinley, who's been a driving force behind moving this legislation, and for his continued leadership on this issue, and would like to express my appreciation to fellow committee members for sticking with us as we continue to push forward to ensure that effective regulation of coal ash. With that, I yield back my time and recognize Mr. Tonko, the ranking member of the subcommittee, for 5 minutes.
Thank you, Chair Shimkus. And on the outset, let me just indicate how pleased I am to be able to work as ranker on this subcommittee with you. I appreciate the fact that our respective parties have asked us to lead the efforts with what I think is very important work that comes under the overview of this subcommittee. So I believe we'll have a very productive year and session and look forward to it. So congratulations on your continued leadership. Good morning, and again, thank you, Chair Shimkus, for holding this hearing on the Environmental Protection Agency's final rule to establish minimum national standards for the disposal of coal ash. Over the years, communities have been subjected to risks due to air and water pollution associated with inadequate management of coal ash disposal. Spills resulting from coal ash impoundment failures have polluted water supplies, destroyed private and public properties, and resulted in lengthy and expensive cleanup efforts. I am certain that the residents of these unfortunate communities feel this rule is long overdue. EPA is to be commended for its extensive process of public engagement on this issue. The agency sorted through over 450,000 public statements submitted during the public comment period on the rule and held 8 public hearings in communities across our country. EPA's rule is responsive to industry concerns that classifying coal ash as hazardous waste would harm coal ash recycling efforts that utilize coal ash in new materials and new products. And it is responsive to the concerns of public health and environmental advocates, because for the first time we have federal standards for coal ash disposal sites that will set a floor of protection for all communities. Of course, the rule from either vantage point is not perfect. Given the disparate opinions on what would constitute appropriate federal regulation of coal ash disposal, that is not too surprising. The rule has quieted the debate on this issue somewhat. But, of course, there are still differing opinions about how coal ash should be classified and regulated, and we will hear some of these opinions here today. I would have preferred to see a stronger regulation given the substantial risks and tremendous damage and cost of recent spills, especially the one experienced in Tennessee in 2008. But with this rule in place, states and utilities can begin to address deficiencies in disposal operations. Communities will gain access to information about coal ash disposal facilities and have a benchmark from which to compare performance against expectations. Now that the rule is final, the work of implementation begins. Ultimately, that is the only real test of whether this rule takes the correct approach or not. And it will take some time to evaluate whether its implementation will achieve the goals of safe management of coal ash disposal. I believe it is this subcommittee's job to continue in its oversight of this issue and others going forward. We will have witnesses today who will advocate for changes to this regulation or to the underlying law, and I think that either approach is premature. I would observe that changes in regulation or in law do indeed take a long time, and hitting the restart button now would only lead to continued uncertainty and risk. We have had far too much of those already. This rule was years in the making. As I said earlier, I would have preferred to see a stronger regulation. But I'm not willing to second-guess an approach that has yet to be implemented or evaluated. And once that rests on the extensive public engagement and negotiating process and years of work invested by the interested parties and the agency, this rule should move forward. We should give this approach an opportunity to work and monitor it closely to evaluate its effectiveness. So let's get on with it. As we go forward, we will see how well this approach works. We certainly retain all options for action if it does not. I thank all of our witnesses for appearing today and for their invaluable contributions to the public process that moved this rule forward. Again, I thank our Chair, Chair Shimkus, for calling this important hearing. I look forward to working with you on this issue and the other issues in this jurisdiction of our subcommittee as we begin our work in this 114th Congress. And with that, I yield back.
I want to thank my colleague for his kind words, and now I'd like to yield 5 minutes to the Chairman of the full committee, Mr. Upton.
Thank you, Mr. Chairman. Today, our multi-year quest to solve the coal ash issue continues in this new Congress, and I want to particularly thank all of our witnesses for appearing today and welcome back a frequent guest, EPA Assistant Administrator Stanislaus. You've worked clearly long and hard on coal ash and have always engaged with us very constructively, and we appreciate that. Navigating this issue is a tough job and, in our view, much more difficult by gaps in current law. Most of us can agree that coal ash does not warrant regulation as a hazardous material, and I'm glad that EPA agrees. But there's no authority in the law that allows for a state-based permitting program for non-hazardous waste. When the federal court set a December 2014 deadline for EPA to publish a final rule for coal ash, we looked at the legal constraints and questioned whether EPA's rule would be the last word on the subject. We, along with some of the witnesses who we'll hear from today, are still asking the same thing, and we're left even with more questions. If we don't legislate, how will EPA's rule be implemented and enforced? Will there be a dual program in each state, one federal and one state-based? Can we expect a dramatic increase in citizen suits? The current regulatory path contains risks for all sides and could lead to even greater uncertainty and expense. Mr. McKinley's bipartisan bill in the last Congress went a long way towards solving the challenges with coal ash management. The legislation recognized that states like Michigan were already running successful disposal programs, and it allowed states to continue to use their localized regulatory expertise. I appreciated EPA's input in our legislative process. The agency acknowledged some of the advantages of our legislation and asked for some changes, many of which we made to the bill. Our goal is to get the job done right, and we're willing to discuss further changes to the legislation to ensure that we have a workable solution in place. We want to continue working with members in both bodies and both parties to achieve the best overall outcome. We'll continue to work with our stakeholders, the states, the utilities, co-ops, coal ash recyclers, and other advocates. Our goals are threefold: put the right protections in place, put coal ash generators and users straightforward standards and procedures to follow, and grant states the authority that they need to implement and enforce federal standards while taking into account distinct local conditions. Mr. Chairman, with all of the innovative ideas and continued refinement that has gone into legislation over the last couple of years, I welcome the opportunity to once again listen to stakeholders as we chart a path forward. I yield the balance of my time to Mr. McKinley.
Thank you, Mr. Chairman. Job creators detest uncertainty. And let's make one thing clear. This regulation, this proposed regulation, does not provide certainty. Now, in the spirit of the Super Bowl upcoming, let me explain with an analogy. If a quarterback knew what defense was going to be put up against him, he knew with certainty what defense, he would logarithmically likely be able to move the ball down the field much more easily if he knew with certainty what he faces. And this is what applies to this regulation. It provides no certainty to the business community. Let me give you three examples, and you've already heard from our two chairmen talk about that. But let me reinforce it again. The rule results in potentially conflicting federal and state requirements. Federal judges in neighboring jurisdictions could make contradictory decisions regarding compliance. But more damaging is on page 18 of the rule. It says, and quote, "This rule defers a final determination until additional information is available." That's not acceptable. How many times must there be a final determination that coal ash is not hazardous and be handled in a different way? In the 112th and the 113th Congresses, the House passed legislation codifying the conclusions that were rendered in the 93 and 2000 reports offered by the EPA. We're trying to develop certainty. Certainty not just to the business community, but to the health of the people that we're trying to protect. In fact, Mr. Stanislaus, and I thank you very much because we've had a good working relationship. You said in the 2013 that the legislation that we passed was something that you could work with. That's what we want to keep working with. We want to keep that relationship going to come up with certainty how that could go. So the bottom line, unfortunately, is we have a regulation that doesn't provide certainty. It would be wise for the committee to once again pass the legislation that we've done over the last 2 years and bring closure to this issue. Thank you, and I yield back my time.
Gentleman's time expired. Chair now recognizes the ranking member of the full committee, Mr. Pallone, for 5 minutes. It was nice saying that, so welcome.
Thank you, Mr. Chairman. I also wanted to start by congratulating my colleague from New York, Mr. Tonko, on continuing his role as ranking member of this important subcommittee. And I think I can speak for all the members on our side of the aisle when I say that we appreciate your expertise and leadership on environmental issues, Paul. Let me just turn to the topic today. I'd like to commend the EPA for finalizing national criteria for coal ash disposal. These criteria will, for the first time, provide the framework for addressing this serious environmental problem. Unsafe disposal of coal ash poses serious threats to human health and the environment. The three primary risks are groundwater contamination, fugitive dust, and catastrophic failure of wet impoundments. And I'm happy to say that each of these risks is addressed in the EPA's new rule. EPA first determined that national disposal criteria were needed for coal ash in the year 2000. That was 15 years ago now, and the need for this rule has only become clearer. We now have 157 documented cases of damage to human health and the environment from unsafe coal ash disposal. It's possible that with the monitoring required under this rule, that number will only go up because more contamination will be detected. And this rule is the product of a robust public process, including field hearings and several rounds of public comment. It reflects the input of over 450,000 commenters, including states, industry groups, environmental groups, and individual concerned citizens. And it addresses many of the concerns that this subcommittee has heard in past hearings. By proceeding under Subtitle D, EPA addressed concerns about stigma raised by industry. By laying out a framework for states to incorporate the regulations into existing programs, EPA addressed state concerns, and by requiring public reporting of monitoring data and addressing some legacy sites, EPA addressed many concerns raised by environmental advocates. We'll hear today that not everyone is satisfied with the rule. Certainly many in the environmental community argue that only a Subtitle C rule would protect human health, and it's possible that the self-implementing nature of the rule could lead to inconsistent compliance. But as a whole, the rule is an important step forward. The rule will offer important protections for human health and the environment, including many important protections that were not part of past legislative proposals. And as we look ahead in this subcommittee, I think the publication of this final rule changes our role. We're no longer called upon to set national criteria in statute because those criteria have been set through a robust, transparent process. Instead, we'll have to monitor compliance and conduct oversight of the rule's novel implementation structure. And I hope we can conduct that oversight in a bipartisan manner. Again, I applaud EPA for their hard work and look forward to the testimony. And I would yield back, Mr. Chairman.
Gentleman yields back his time. And I want to thank my colleagues again. Now I'd like to recognize Matthew Stanislaus from the EPA. Thank you for coming. I think you heard from a lot of members of, this is one issue we really appreciate the work that we've done together, and we look forward to working with you more. You're recognized for 5 minutes.
Good morning, Chairman Shimkus, Ranking Member Tonko, and members of the subcommittee. I am Matty Stanislaus, U.S. EPA Assistant Administrator for the Office of Solid Waste and Emergency Response. And I and my staff has had the privilege of working the last 5.5 years to actually get it right in terms of putting a rule in place that is protective and address the risks that we have identified. On December 19th, as members know, EPA finalized the coal ash rule. This rule established the first ever national rule for the safe disposal of coal combustion residuals in landfill and surface impoundments. The 2008 catastrophic failure of the CCR impoundment at Tennessee Valley's Kingston facility, EPA's risk assessment, and the 157 cases in which CCR mismanagement has caused damage to human health and the environment clearly demonstrate that improper management of coal ash poses an unacceptable risk to human health and the environment. We believe this groundbreaking rule is a culmination of extensive studies on the effects of coal ash on the environment and public health. The rule establishes technical requirements for landfills and surface impoundments under Subtitle D of the Resource Conservation and Recovery Act. In developing this final rule, EPA carefully evaluated more than 450,000 comments, testimony from 8 public hearings, supplemented by 3 separate public comments on data, which is the foundation of the rule. The rule is strong, effective approach that provides critical protection to communities across the nation by helping to protect our water, land, and air. The rule protects groundwater by requiring utilities to conduct groundwater monitoring, immediately cleaning up contaminated groundwater, closing unlined impoundments that are contaminating groundwater, and requiring the installation of liners for new surface impoundments and landfills. It protects communities against catastrophic failure of impoundments by requiring specific design criteria, inspections and engineering testing, and to retrofit or close impoundments that fail testing. It protects communities from CCR dust by requiring an air control plan. Further, the rule provides states and communities the information they need to fully engage in the rule's implementation. The rule requires utilities to post information on all aspects of its compliance with the rule on publicly available website to help ensure states and the public have access to information to monitor a utility's compliance with the rule. The rule has been designed to provide electric utilities and independent power producers generating coal ash with a practical approach for safe coal ash disposal and has established reasonable implementation timelines for this to occur. We strongly recognize the important role that our state partners play in implementation and ensuring compliance with environmental regulations. EPA is committed to working closely with our state partners on rule implementation, and as a major component of this rule, states can align their programs with the federal rule by utilizing the solid waste management planning process and submit revisions limited to incorporating the coal ash federal requirements for EPA for approval. The solid waste management plan can demonstrate how the state program has incorporated the rule's minimum criteria, utilizing state permit or other processes, and can highlight those areas where state regulations want to be more stringent or otherwise go beyond the federal minimum criteria. EPA will be working with the states to develop a template for a streamlined process for developing and approving the solid waste management plan. Of course, the final rule does not preclude a state from adopting more stringent requirements should it choose to do so. I should note that states would have adequate time to develop the solid waste management plan and seek EPA's approval and conduct the necessary public process, because the major elements of the rule is at least 18 months from today. Further, the rule supports environmentally sound beneficial use of coal ash. The final rule does not change the current bevel exemption nor regulate coal ash that are beneficially used. The rule distinguishes between beneficial use and disposal to provide certainty to the regulated community and to users of coal ash. We have separately established methodology for coal ash users to analyze their products, and we have in fact applied that methodology to demonstrate that concrete and wallboard that we've confirmed its continued use. I will close by noting that we believe this is a tremendous milestone to protect communities and the environment in which we live and work, and EPA is committed to working with our state partners, local communities, and utilities on the implementation, and I look forward to your questions.
Thank you very much. Now I'd like to recognize myself for 5 minutes for opening round of questions. So again, numerous times we appreciate your good effort and good work, and we look forward to working with you. But just to get some clarification, and we got your partners sitting behind you who will be also working within their states. Under the final rule, no permits will be issued. Isn't that correct?
Well, what we've identified utilizing the solid waste management planning program is the states can build a permitting program and submit that for EPA to be approved.
They can, but there's no requirement to. There's no permitting process in the new rule.
That is true, but once the solid waste management plan is approved, there will be a singular point of compliance. So utilities can then implement through the state program, and we have been made clear in the preamble, but that compliance will demonstrate compliance with the federal.
And you understand why we're asking that, because the legislation we moved last cycle said federal standards, state implementation, permitting process where there's certainty, and I think it goes to Mr. McKinley's point. Isn't it true that states are not required to adopt or implement the requirements?
Well, clearly they are not required, but the states have clearly called on us to figure out ways of aligning the federal requirements with the state program. That is why we've established a solid waste management planning program, so the states can in fact integrate the minimum federal requirements that we've established within the state program, seek EPA's approval of that, and so that will establish the alignment from our perspective.
Okay, neither EPA nor the states can directly enforce the requirements in the final rule. Isn't that correct?
That is correct. So we believe, again, utilizing the state solid waste management plan, the states can then go forward and implement these requirements once a state solid waste management plan is approved, or independently, states can and citizens can implement requirements of the rule.
Yeah, and under your rule, the only enforcement mechanism under the recently reduced rule is through citizen suits and more litigation. Is that correct?
Well, we actually believe, again, that the state solid waste management plan, when approved, will not result in excessive litigation. There will be litigation to enforce in those circumstances where states and others deem not to be compliance.
You're more optimistic than I am, I can guarantee you that. Even if states adopt the federal rule, utilities will have to comply with the state requirements and the federal rule. Is that correct?
Well, the rule is directly applicable to utilities. But again, getting back to the state solid waste management plan, there is an opportunity for the states, as the states have sought, to align and integrate the federal minimum requirements into their program and seek EPA's approval for that.
But you understand the concern in this line of questioning is it's kind of vague. They can or they might. We kind of hope they do. We hope there is an expectation that they probably will. But there's not a lot of clarity. And then the other concern is if you're relying on citizen suits, or citizen suits will come, right? There's no doubt that they will come. And if they are regionally directed, then you could have multiple standards throughout the country which aren't the same based upon the litigation and the rulings in these different courts. Isn't that a concern?
Well, actually, we don't anticipate that. The rule is pretty specific in establishing a minimum federal requirements for protection of groundwater, for preventing catastrophic failure, for addressing dust. And so we don't think, so if you move forward in implementing that, and the states can integrate that within the state program, and EPA approves the state solid waste management plan, we think that there is going to be national consistency.
You are more optimistic than I am. And just you mentioned the preamble, so let me kind of address that. If a regulated facility complies with a state requirement that is more stringent, and therefore it's not the same as the requirement in the final rule, will the regulated entity also have to comply with the federal requirement?
So I just want to clarify. So if a state adopts more stringent, adds to the federal requirement,
correct,
then gets an approval from EPA through a state solid waste management plan, the utilities would then have to comply with fully the state requirements. And so that will demonstrate compliance with the federal requirements and also additional requirements that the state chooses to add.
Yeah, and I think we're going to hear testimony in the next panel that they don't believe that that's true, that there'll be a twofold process, the federal government and the state EPA, and that's one of the concerns that we have with the rule. So good people can agree to disagree, and I'd now like to recognize the ranking member of the subcommittee, Mr. Tonko, for 5 minutes.
Thank you. Mr. Stanislaus, good morning, and thank you for joining us. Unsafe disposal of coal ash poses serious threats to human health and to our environment. That is why I'm pleased that EPA has finally set national criteria for state disposal of coal ash. For the first time, utilities and states have clear requirements to indeed follow. As I stated earlier, I would have preferred a stronger rule. Public health and environmental advocates have indicated that they have preferred a stronger rule. I tend to agree, but I do believe the rule includes some important safeguards. I appreciate you being here to testify, and I would like to go over some of the most important protections offered by the rule with you. To ensure that disposal sites are not located in dangerous areas, the rule puts in place 5 restrictions, and I'd like to give you my read of those restrictions and see if I'm interpreting them correctly. Structures generally will not be allowed close to aquifers, in wetlands, within fault areas, in seismic impact zones, and in unstable areas. Is that indeed correct?
Well, that is correct. So they're going to have to do an analysis of with respect to those location requirements and demonstrate whether they can safely operate and putting engineering measures to prevent any impacts.
Okay, thank you. And previous legislative proposals we've seen would have included only 2 of these 5 restrictions and included a smaller aquifer buffer. I appreciate that the final rule includes these protective requirements. Next, to protect air quality, the new final rule will require facilities to develop dust control plans and prevent blowing by wetting or covering the dust or erecting wind barriers. Is that indeed correct?
That is correct.
Thank you. To detect groundwater contamination, the rule includes requirements for at least 1 up-gradient well and 3 down-gradient wells. Is that correct?
Yes.
Why did the agency find it important to specify a minimum number of wells?
Well, there's a standard protocol to make sure that we fully understand the direction and potential impact to groundwater.
Okay, lastly, I would like to turn to the public disclosure requirements in this rule. The rule establishes a national floor for what information will be made publicly available and for how that will be done. Utilities will have to maintain pages on their websites that document their compliance with a wide range of the criteria in the rule, including location, design, and groundwater monitoring. Is that correct?
That is correct.
These disclosure provisions in the rule will be essential to ensuring compliance and promoting transparency for communities. Although a Subtitle C rule might have offered more protection and more direct enforcement, this rule will protect human health and the environment and goes beyond past bills. I do want to commend EPA for finalizing this rule and for the agency's conduct of the extensive public engagement in the course of this development. And with that, I thank you for appearing here this morning, and I yield back.
Gentleman yields back his time. Just a notification to my colleagues. The votes have been called. We have about 10 minutes before a lot of us need to get there. That means I think we get 5 minutes on each side, and then we'll recess and have folks come back to finish this panel. So the chair now recognizes the vice chair of the subcommittee, Mr. Harper, for 5 minutes. And congratulations on your elevation.
Thank you, Mr. Chairman. Mr. Stanislaus, in light of the fact that the final rule requires the cleanup level to be set at either the MCL or the background level, if a state chooses to incorporate risk-based decision-making into their coal ash permit programs that establish an alternative groundwater protection standard, would EPA be able to approve the state plan as being as stringent or more stringent than the final rule?
So let me break it down. I think there are a couple of subcomponents. So, we've integrated the same standard framework as a Superfund cleanup. So we begin with protecting groundwater in all cases. However, you can look at, in selecting the cleanup remedy, you can look at this particular circumstance that is involved in the cleanup. So in the same way that we provide all those on-the-ground factors, that can be brought to bear in these decisions. With respect to an approval of a cleanup plan, again, in the EPA's approval of solid waste management plan, the states can choose to enable the state's approval of the cleanup plan. So I think there is that ability for states to do that.
Mr. He just finished.
Well, let me just ask this. If a state determines that if there is no human receptor for the groundwater and that a cleanup standard above the MCL or background is appropriate, would that meet the minimum requirements of the rule?
So let me get back to you on that.
Okay. If you'll let us know.
Sure.
I'll just yield back.
Gentleman yields back. Chair now recognizes the ranking member of the full committee, Mr. Pallone, for 5 minutes.
Thank you, Mr. Chairman. There's no question that coal ash can pose serious risks when not disposed of properly. Many people in this room have spent the better part of a decade working on this issue, and I commend EPA for finalizing this rule. I wanted to ask Mr. Stanislaus, do you have a confidence that this final rule is protective of public health and the environment? And in your view, are there gaps in the protections under this rule that would need to be filled by legislation?
I believe the rule is very strong and very protective of the risks that we've identified.
And in terms of any gaps that would need to be filled by legislation?
No, we don't believe there are gaps. We believe for all the risks and all the information contained in the record, we put in place all of the rigorous technical standards to provide the necessary protections.
Well, what about beneficial reuse? Will this rule restrict beneficial reuse in any way to stigmatize coal ash?
We don't believe it will. We provide real clarity with respect to beneficial use, and the beneficial use is not subject to the rule.
But still, I expect we're going to hear from the second panel that legislation is needed to remove EPA's authority to regulate coal ash under Subtitle C in the future. What factors might lead EPA to someday regulate coal ash under Subtitle C?
Well, to be clear, we had proposed an approach under D and C, and we've made a decision under D, so the C proposal is no longer on the table. So like any other rule in the future, we will, it will go through the same rule, a public notice and comment to evaluate future considerations. However, I would note that we have a strong confidence that between the national criteria, strong national criteria, and the utilization of the State Solid Waste Management Planning Program, and EPA's approval of that, that we believe moving forward that we will kind of have the protections that are necessary to protect communities, and we are moving forward and working with the states on implementation.
I mean, I think it's safe to say that if coal ash does not become more toxic and implementation of Subtitle D is effective, EPA would have no reason to pursue a Subtitle C rule. But if it turns out that ash does become more toxic and we find that states and utilities are not doing enough under the Subtitle D rule to protect human health, if that turned out to be the case, would it be important for EPA to be able to pursue Subtitle C regulation, in your opinion?
Well, again, our focus right now, we have reflected and evaluated data and comments by all stakeholders, and we believe we put in place a rigorous rule to offer the protection to communities around the country. So we are moving forward on implementation, working with states, working with public stakeholders, working with utilities to provide the protection. So we're not looking at further rulemaking at this moment.
No, I understand that, but I'm just saying, because of those who advocate that you shouldn't be able to pursue Subtitle C regulation or to eliminate that option, if it turns out that the ash is becoming more toxic and that the states and utilities aren't doing enough under Subtitle D, do you think it would be important for EPA to continue to be able to pursue Subtitle C regulation in that eventuality?
Well, like every other rule, we will look at implementation of this rule and see what issues are unaddressed in the future.
So you don't want to comment on the possibility of pursuing Subtitle C regulation or whether that's important?
Yeah, not at the moment.
Not at this time. All right, thank you so much. I yield back, Mr. Chairman.
Gentleman yields back his time. I think we'll recess now and come back immediately after the vote. There should be 2 votes. You all have time to stretch and get a cup of coffee, but most of us will come back promptly after the second vote. So this hearing is now recessed.
Some light reading. Hey, how are you?
It was like whiplash and trying to recover from whiplash.
I'm going to call the hearing back to order, and I think the next order of business is recognizing the gentleman from West Virginia for 5 minutes for his round of questions.
Thank you, Mr. Chairman. Thank you again for your appearing. And again, as I said in my opening remarks, I appreciate the working relationship we've had with it. Just a couple, maybe 4 quick questions, 3 or 4 quick questions, 2 of which, Mr. Stanislaus, might be just yes or no. But the first one is, do you personally think that coal ash is a hazardous material?
Well,
Yes or
we've
no?
identified the various risks associated with coal ash mismanagement, and we put in place the technical requirements to be protective against those risks. And we've identified the various constituents in coal ash and the ways that we should establish, for example, liner and groundwater program to be protected.
Which is in and of itself as a material, whether that's in concrete, drywall, or liners.
Well,
yeah, but yeah, let me go from there. With the legislation that we passed over the last 2 Congresses, in the 12th and 13th, 12th, would that have created certainty within the recyclers and the utility industry?
Well, you know,
You don't think it would?
well, what I can say is, with respect to the rule, we think it provides the kind of certainty.
Well, no, I'm not talking about the rule. I'm talking about the bill that we had.
Yeah.
Because what my remarks again, Stanislaus, were all about certainty. I come from the business world.
Yeah.
We need to have certainty, and I was trying that legislation was trying to get that. Unfortunately, I believe I know it was a reasonable effort, but it doesn't create certainty. So my last question might be that this proposed rule provides us no assurance that coal ash will not be regulated as a hazardous waste in the future. So could you explain the agency's justification for leaving that door open and almost deliberately causing uncertainty on this issue? Can you explain why they kept the door open instead of closing it so that we could advance?
Yeah, I actually think that we provide tremendous certainty in the final rule, and we've explained in numerous situations. For example, in beneficial use, I think we made very clear that beneficial use is not subject to the rule, that the existing bevel protections will continue to remain, and we think that, coupled with other actions that we've taken, will foster not only the stabilization but increased use of beneficial use. So.
Well, how do you deal with that line and on page 18? It says this rule defers, postpones a final determination until additional information is available. I just wonder how that's like the door's wide open. Because sometimes someone is going to make another determination that could be based on other information, and so I don't agree with you that there's certainty at all in this legislation. I think it was well intended. It helps us resolve the differences between C and D, but it still doesn't give us a view of tomorrow. So if we're going to move the ball downfield, I've got to find out, how do we shut the door?
Well, I actually, in my opinion, I don't think we left the door wide open. I think we've been very clear as between the 2 proposals that we had put for public comment. One is a C approach and a D approach. We went with the D approach. The language that you're referring to then goes on to say that we didn't have full and complete information in a couple areas. One big area was how states would move forward with their programs. So we believe very strongly that the combination of a clear, consistent federal set of criteria coupled with the solid waste management planning program and EPA's approval of that will provide comfort and certainty with respect to those issues. So we actually don't think that the door is open.
I guess, like you said earlier, we're just going to have to agree to disagree on that, because I think it's clear from business perspective, when you have that language that something can happen in the future, the next administration could come out with a different attitude towards it than you personally have had. It makes it uncertain. So we need to just close that. So let's continue working together on that and see if we can't close the door on that.
Yeah, and
so
again,
yield back and balance.
I'll reaffirm, my and EPA's commitment to continue to work with you and this committee on technical assistance. But we also made clear in the preamble that we would not do anything without any. We think we've done a good job and provide the protections, but any future changes, like any rule, is going to be subject to a future process. It would have to require another proposal, another notice and comment. So.
Gentleman's time expired. Chair now recognizes the gentleman from Pennsylvania, Mr. Doyle, for 5 minutes.
Thank you, Mr. Chairman, and I want to thank you for convening this hearing on this final rule. Many of my constituents were concerned by the proposed rule on coal ash disposal because of concerns that it might limit beneficial reuse on the one hand or fail to protect the public health on the other. But I'm generally pleased with this rule. EPA has protected beneficial reuse and put in criteria that will ensure safe disposal. Mr. Stanislaus, I'd like to ask you just a few questions. The final rule prevents or restricts. Does EPA's new final rule prevent or restrict beneficial reuse of coal in any way?
No, beneficial use is fully protected and not subject to the rule.
In fact, coal ash that's beneficially reused won't be subject to the disposal requirements in the rule. Is that right?
That is correct.
And in fact, according to the final rule, 52 million tons of coal ash are beneficially reused annually. Can you tell us about some of the environmental benefits of recycling coal ash instead of sending it to a landfill or wet impoundments?
Sure. I mean, saved energy costs, reducing greenhouse gases and reducing impacts to the environment, as well as the tremendous economic benefits of replacing virgin material with coal ash.
Thank you. I want to move on to what we've been hearing a lot of discussion about. You're going to hear a lot about this self-implementing requirement for this rule, and I wanted to give you the opportunity, and I know you've talked a little bit about it already, on this concern that we're creating a dual regulatory regime, potentially requiring owners and operators to adhere to two sets of standards. What does it mean so the EPA will approve these state plans, and you say that they'll be approved as long as they demonstrate federal compliance? What does that mean? What does that terminology mean?
Yeah, sure. What states would have to do is to integrate the federal criteria into the state program.
So you're saying that any state plan that EPA would approve would have within its plan the federal requirements. So there's no way that any state would be out of compliance with the federal requirement if you've approved their plan, because that will be at the very minimum what their plan has to adopt, and then they can do something over and above that?
Well, that's right. And so from a utility compliance perspective, once that approval happens, the states would have to comply with a single set of information, have comfort that EPA has approved, and made very clear in the preamble that if a utility follows a state program that is subject to EPA's approval, EPA will deem that compliance with the federal criteria.
So what you're saying, in effect, that if a state adopts that plan and the utility implements it, that there's no way they can be out of compliance with the federal statute. They could be out of compliance with the state one if it has extra provisions within it.
That is correct.
But you feel that addresses that concern about the dual regulation?
We do.
Okay. That's all the questions I have, Mr. Chairman. Thanks.
Gentleman yields back his time. The chair now recognizes, it looks like the gentleman from North Dakota, Mr. Kramer, for 5 minutes.
Thank you, Mr. Chairman, and thank you for being here and for your good work on the rule. I just have one area, and I'm going to continue on this line of exploring a little bit on the self-implementing piece, because I spent a number of years on the North Dakota Public Service Commission, carried the coal reclamation portfolio, and the one thing that I heard a lot, and especially in whatever the case might have been, but whenever we were challenged in court, and we were plenty of times, and we always prevailed as a commission, not because our lawyers were superior or anything like that, although we have good lawyers, don't get me wrong, but because the courts in highly technical matters just always defer to the experts, to the administrative agency. And so this self-implementing thing just it makes me a little nervous, and if it makes me a little nervous as a former regulator, I can only imagine how nervous it makes the industry. And it just seems to me that we could tighten it up and provide the certainty that everybody's talking about without compromising in any way, really, the protections that we're trying to accomplish. And in fact, I think should be to the benefit of everybody on all sides. Am I wrong there, or is there a better reason to do it this way, to do the self-implementation?
Well, I don't disagree with the overall views, that courts will provide substantial weight to the technical judgment of states and federal government. So, precisely for the reason that you raised is the reason why we're tying these minimum federal requirements to an EPA approval of a state program, because we believe very strongly that the courts will look at that and provide substantial weight to that technical judgment of a combination of the states and EPA.
I understand all that, and I think that's noble. That's why I'm just saying, can't we just go the next step and tie it down so that we're not relying on self-implementation and then the discretion of multiple jurisdictions and multiple courts when we have the experts in what seems to be pretty relative agreement for this place, and and then just tie it down. I think you get a lot of support. But that's really all I have, and I again appreciate the hard work.
Gentleman yields back his time. Chair now recognize the gentleman from California, Mr. McNerney, for 5 minutes.
Thank you, Mr. Chairman. Thanks for holding the hearing. Mr. Stanislaw, how many tons of coal ash are produced in a year in this country?
How many tons? I don't have that number.
Any idea about what fraction of that is used in beneficial ways, for construction or road grade material or so on?
I don't know off the top of my head. I believe it's about 30%, but I can get back to you on the actual numbers.
Is there more opportunity for beneficial use of
absolutely.
coal ash?
Absolutely.
How would that happen? What would it take for more beneficial uses to come about?
Well, I think probably Tom Adams would probably be a better witness to ask that. But I think clearly when we've discussed with the reuse manufacturers, providing the certainty that I think will be provided will be a first step into to expanding the beneficial use of coal ash.
So that's a part of the rule that's been promulgated.
That's right.
Okay. I'm a little concerned about citizen lawsuits with regard to the rule or the potential legislation that might come out of this issue. How quickly do you think that we'll start to see improvements in the safety of coal ash disposal sites as a result of the rule that's been promulgated?
Well, I think we will begin immediately. So the rule takes effect in basically 6 months from publication, which should be in about a month or so. So there's some early obligations, like making sure you have a dust control plan in place, make sure you begin the inspections. I think you will see some early improvement. A lot of these are things that are already done by some of the leading utilities anyway. So I think that's going to be more of a standardization around the country. And then as time progresses, roughly in about 18 months, some of the more structural issues would be addressed, those things that potentially contaminate groundwater, potentially have an impact on structural stability would be addressed.
Good. Do you expect the robust transparency provisions to incentivize compliance?
Oh, absolutely. I think all the studies show that the more disclosure of data and compliance in a very deep and granular way, I think it's an incentive for compliance, and also it enables citizens adjacent to these facilities and the states to monitor compliance.
And do you think that the citizens in the states are going to buy the disclosures that the disposal agencies are going to be putting out on their websites? Do you think the people are going to buy it, or do you think they're going to revert to lawsuits to satisfy their concerns?
Well, I think that one of the reasons that we put in this public disclosure was to respond to citizens' request of having detailed information, for example, groundwater data and how the groundwater data compares with whether it is or is not exceeding protectedness standards. So I do think that it's going to add substantial value to compliance and oversight by citizens.
So there's enough teeth then, in your opinion, in the compliance requirements that people will take satisfaction that they're actually doing what they're saying?
We do. We do.
The last question, is there a concern that if the committee passed a bill that was signed into law, it would stifle the beneficial use of coal ash or the safe disposal of coal ash? You think that passing a law would stifle what's going to take place as a result of the rule? Well,
I really cannot really answer that question today in a vacuum. What I can say is that we strongly believe the rule provides a protection as well as a certainty, protection for communities next to empowerments as well as certainty to the beneficial use market. So, I really can't provide an opinion as to what the effect of any legislation would be regarding certainty at this moment.
Okay. I'll yield back, Mr. Chairman.
Gentleman yields back his time. Before I yield to Mr. Flores, I want to ask for unanimous consent that a letter written today by the U.S. Green Building Council be submitted for the record. Is there objection? Hearing none, so ordered. Now I'd like to recognize Congressman Flores from Texas for 5 minutes.
Thank you, Mr. Chairman, and Mr. Stanislaw, thank you for joining us today. I want to give you a quote in answer to the question about having multiple opinions of judges determine how the enforcement is carried out. You said we don't anticipate any issues with that in that regard. I will tell you from a real-world perspective, any time that you don't have the right type of rulemaking, that you will have that instability, if you will, in the real world in terms of the enforcement process. And not only could you have it among the states, you could have it within a state because you've got multiple district judges that will make their own technical opinions. So I urge you to keep that under consideration as you move forward. This gets into the law, if you will, and that is in terms of legacy sites. Walk us through how the EPA believes that it has the authority to regulate legacy sites. And in particular, I'd need the specific reference to RCRA, if that's what you're relying upon to make the rules.
So clearly, we've set forth in the rule that inactive sites at a active power plant and active units at a power plant have the same exact risk. This has coal ash with all of its constituents of coal ash. It has water. And under those conditions, it poses the identical risk of structural failure and impacting communities, leaching into groundwater. So we believe because of those circumstances that RCRA provides us the ability and authority and kind of mandate that kind of protection, because identical units, but for it's not actively being used for disposing of coal ash.
Okay. Let's take that to the next step when you're talking about those particular impoundments. When you propose the application of location restrictions to existing surface impoundments, the EPA acknowledged that these limitations, the location restrictions, would force a majority of these the current impoundments to close. And so do you have an estimate of how many will close, and moving further upstream from those closures, what sort of reliability does that, reliability issues could be imposed on our grid?
Yeah. Well, I don't have that estimate. I can get you that information. I believe it's contained in the preamble, but I can get you that information. But just to be clear, the final rule provides location requirements, but it does not begin with closure. It begins with examining all these location criteria: proximity to wetlands, proximity to groundwater aquifers. Then a utility will have to determine whether they are not in compliance with that. Then they will have to determine, can they put in engineering solutions to provide those kind of protections. So it would not automatically trigger closure. But I can get you that data.
Okay. I think that would be important, because I think in your rule, you acknowledge that it will cause the majority of these to close, and I think that creates an issue in terms of reliability.
I'll look at that. I'm not sure that's correct, but I'll check that and get back to you.
And then, to the extent that an operator grants itself an extension, what do you think the impact will be in terms of citizen lawsuits and the instability, let's just say the instability or the lack of clarity that causes for an operator?
Well, because we've gone out, we visited numerous coal ash impoundments around the country. We've reviewed information from utilities about the different dimensions of impoundments, and because some are going to be more challenging to close than others, so we do put in place in a very specific way those circumstances where they can provide, enable themselves of extension. So we think the rule itself provides that ability to extend where the circumstance justifies that. That would be coupled with, obviously, the utility disclosing those circumstances. But we believe once you follow that, there will not be a violation of the federal rule.
Okay, and therefore no citizen litigation would follow then?
Yeah, we don't believe there will be a basis for citizens in that circumstance.
Mr. Chairman, thank you. I yield back.
Gentleman yields back his time. Chair now recognizes the gentleman from Ohio, Mr. Latta, who was actually very involved in pushing this legislation too in the last couple of Congresses.
Well, thank you very much, Mr. Chairman and Mr. Administrator. Thanks very much for being with us today. If I could just go back, I know that there's been a lot of discussion already on the beneficial use of coal ash, and I know we've had different panels in here over the last couple of years talking about it. But one of the things I know that you had mentioned a little bit earlier, because when you said that in your testimony that approximately 40% of CCR generated in 2012 was beneficially used. But again, in the testimony that we heard, we have states out there that are saying, boy, if the EPA would ever change its mind, we're going to require buildings to have things ripped out or something like that. So you got school districts saying, well, we don't want to use material that might in the future have some kind of EPA coming back and saying that it could be hazardous. When you use the term certainty that you've mentioned, what is the certainty that the EPA can give to folks out there that there's not going to be a change? Because again, if it's road material or it's block material, but it's that material that is actually being used inside of a building that a lot of folks are worried about, school districts are worried about. So how do you define certainty, and how do we make sure that the folks out there have that certainty of mind that the EPA is not going to change in a couple of years what they're defining as a hazardous or non-hazardous material?
Sure. Thank you. So even before the finalization of the rule, because of this issue of certainty and risk and comments that we received from the beneficial use industry, we first began by developing a methodology to evaluate the continued use of beneficial use. We used that methodology and applied it to encapsulated uses, and we confirmed that concrete and wallboard, the largest two uses of beneficial, can continue to move forward. So we believe that provided a significant certainty, and I know Tom Adams can speak for himself later on the panel. Secondly, we also heard that this cloud, some advocates have noted, and that the cloud of uncertainty of not finalizing the rule continues to create some uncertainty, and that we believe our decision to go with a D proposal as opposed to the C proposal provides a second set of certainty. So the C proposal is no longer on the table. So we actually believe that we provide a substantial certainty to the market. And I'll let Tom talk more about it.
When you talk about the methodology, how do you go about that? Who's at the EPA? Who's sitting down at the table to really come up with a methodology to come forward with that standard, or what that should be set at?
So we've engaged particularly the beneficial users in the development of the methodology. So this is a methodology to be used by users, by manufacturers, or by states to confirm that a product that uses coal ash as opposed to a product that doesn't use coal ash are comparable, and so therefore it can be safely used to replace virgin product. So, we think that the methodology has been well received in the marketplace, and on application of the methodology to these specific uses like concrete and wallboard has been well received.
Okay, thank you. Mr. Chairman, in the interest of the second panel, I'm going to yield back the balance of my time.
And I thank you for that. Chair now recognizes the other gentleman from Ohio, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Director, for being here with us this morning. I want to get a clarification on something you said earlier. So the state program does not operate in lieu of the federal program, correct?
That is correct.
Okay. So if the state program does not operate in lieu of the federal rule, then both sets of requirements are still enforceable, correct?
Well, that is precisely because we've heard those comments during our public comment process about the possibility of precisely that. That is why we strongly believe that there's a vehicle to integrate the federal requirements into a state program and have EPA approve that state program to have that alignment occur.
Okay. So for corrective action, the final rule requires that if a constituent of concern is detected above a statistically significant level, that the groundwater protection standard must be set at either the maximum containment level or at the background concentration. Whereas the proposed rule, like the municipal solid waste program, would have allowed the operator, the owner or operator to establish an alternative groundwater protection standard based on site-specific conditions. So how does the EPA anticipate that this will impact ongoing corrective action at coal ash disposal units in states that utilize risk-based decision-making?
Well, we believe the risk-based decision-making that is core to a cleanup determination will continue. Now, what we've done in the rules, we've brought the various factors that's used in the Superfund program to do exactly what you noted, to consider those site-specific factors. So we always begin with protecting groundwater, protecting the highest use of groundwater. But then when you go and look at the specific cleanup remedy that fits a particular situation, you evaluate the various technical factors in determining the cleanup that is most appropriate to achieve the cleanup that's protected.
So that ability to establish an alternative groundwater protection standard based on site-specific conditions, that would still be there in your view?
Yeah. So what a utility would do is then look at the various factors, no different than a Superfund cleanup, and establish the cleanup option that best fits. No, so I'll just leave it at that. Yeah.
Okay. Going down to closure, if the owner or operator puts forth a realistic closure plan and indicates that the facility needs more than the required amount of time to close in a safe and appropriate manner, technically the plan doesn't meet the deadline. Is the owner or operator out of compliance with the final rule in that case, and at what point is the owner operator subject to lawsuit when it puts out the plan with the longer closure date, or when it actually doesn't meet the 5-year deadline? Mm-hmm. So you've got an owner operator that says it's going to take me longer than the rule allows to do it properly. What happens?
Yeah, that was we've received numerous comments precisely on that topic. We believe the 5 years is adequate for many of the units, but there are going to be some units because of the size, because of the particular geology, is going to require some additional time. So in the rule, we built in that opportunity if a utility can demonstrate that those conditions exist, and we articulate various timelines so they can avail themselves of those additional timelines set forth in the rule.
Okay. All right. Mr. Chairman, so we can get to the second panel, I yield back as well.
Gentleman yields back his time. The chair now recognizes a new member of the subcommittee, Mr. Cardenas from California, for 5 minutes.
Thank you very much, Mr. Chairman, and thank you so much for having this hearing. Mr. Stanislaus, I'd just like to ask you, do you have a technical background?
I do.
What would that be?
I'm a chemical engineer before I became a lawyer. So.
Oh, okay. And they don't cancel out. I think they go well together. Don't. Well, thank you very much. I appreciate that because I think that when we're talking about EPA and we're talking about regulations, especially when it comes to things like coal ash, I think that there is some science that goes into those decisions, correct?
That's right.
And evaluation and understandings, and then even beyond science per se, it also goes into probabilities of and cause and effects and things of that nature, correct?
That's right.
Okay, well, I'm glad to know that you've got that engineering background. I won't speak of your law degree, but at least engineering background. I'm not a lawyer, but I'm an engineer, so I appreciate that. Now, when it comes to EPA's new rule, which will set national criteria for the location, design, and maintenance of the ponds in protecting all of the communities that live with this potential risk, first of all, I'd like to applaud the EPA for moving forward, but also this effort is important, especially because has it been determined or evaluated by the EPA as to who most likely is affected by this activity in these ponds? Is it more affluent communities, more low-income communities? Is there a disproportionate effect when it comes to communities that are affected?
Yeah, I'm not sure we've done a specific demographic analysis. Clearly, the communities that are adjacent to these facilities that potentially get impacted by catastrophic failure for contaminated drinking water.
Mm-hmm. Okay. Well, I know that in the Los Angeles basin, if you just look at the geographic area and if you look at income demographics, there definitely is a skewing of one side of town has a lot more activity where this might take place, and the other side of town, which might be more affluent, doesn't have hardly near any of this kind of activity, but at the same time, maybe none of that activity for zoning purposes and activity permits and things of that nature. So I'm just reflecting on what goes on in the LA basin, and even with coal ash, by the way, specifically, not just coal ash, but other elements as well. So one of my questions to you, Mr. Stanislaus, is can you describe some of the ways this rule will make coal ash ponds safer for vulnerable communities surrounding them?
Sure. It begins with trying to prevent a catastrophic failure. And as we know, the TVA incident occurred, essentially destroyed a community, caused about $1.3 billion of impact. So it contains a rigorous set of requirements to prevent those kind of things. Regular inspections, structural evaluation, engineering evaluation, and based on that evaluation, impoundments will either have to enhance the structural stability, or if they cannot do, they would have to close that facility. With respect to preventing groundwater, it begins with putting in place a comprehensive program of groundwater monitoring. The groundwater monitoring exceeds protective standards, immediately moving forward on cleaning up the groundwater, and in situations when online impoundment exceeds the groundwater protection standards, then they would have to close. So those are some of the elements. And also the other big issue is dust. We've heard from many communities about coal ash dust. So we put in place a comprehensive program to control coal ash dust from migrating into communities.
Okay. Now, the EPA, when you make this rule, how do you come about it? And too many people, in my opinion, whether elected or not in this country, keep thinking that anytime you have regulations, they're just trying to hurt business. I mean, what kind of effort goes into making sure that you strike some kind of balance and understanding of what's going on in the real world and what should happen to create the public safety requirements that we should have? Should we have standards in the United States of America?
Sure. I mean, I didn't begin with kind of listening and evaluating all the comments that we received from everyone. Clearly the community is impacted, but clearly we have to have an implementable rule. And so we looked at the pragmatic issues of how can it be implemented in a realistic way that considers the on-the-ground circumstance of size and magnitude of the unit. So we think it's a protective rule and a rule that is pragmatic and considers its on-the-ground construction issues.
So you're not just going into this blindly without understanding and appreciating what's going on in the real world on the day-to-day effects of a particular industry.
That is right. It's very much data-driven and scientific-driven and reflecting the comments we've heard from all stakeholders.
Okay. So commerce is something that's taken into account as to the flow and the effects of commerce when these decisions and or these processes are discussed?
Oh, sure. We want to make sure that, again, the challenge of closure and the relative size of that, and also kind of avoiding, the billion-dollar consequence of these catastrophic failures. All of that goes into our consideration.
And are there more examples outside the United States of incidents, catastrophic incidents, more than in the United States so far, as your data and research shows?
Yeah, I was based purely on the U.S. Information, so I don't know the answer to that question.
Well, what I would like to recommend, that I know that I don't think it's beyond your purview to at least understand what's going on in the rest of the world, because especially since the world is getting smaller with all this international commerce, I think it's important for us to understand as Americans how having regulations here that don't happen in other parts of the world, how people are affected when they don't have that. And I think that as Americans, we're kind of spoiled by what we don't see in the regulations that do, in fact, protect us. And if point of personal privilege, I'd like to correct myself, Mr. Chair. We don't have coal ash in the LA Basin or in California, but I was thinking about the piles of petroleum coke that we have in the LA Basin. So I apologize and I want to correct myself. Thank you so much, Mr. Chair. I get back.
You're more than welcome. It's great to have you on the subcommittee, and we could provide you some coal ash if you would like some in the LA Basin on some rail cars. How about that? So we want to thank you for coming. Again, great work. We'll listen to the second panel and see what it shoots. I would expect that we would try to maybe look at some of these tweaks that you've heard about today. And with that, we'll dismiss you and we'll impanel the second panel. So thank you very much for coming. So as our second panel is being seated, just for the sake of time, I'm going to, I've done this numerous times, I always mess up, so I think I'll just do the introduction of each person right before they give the 5-minute opening statement. Our panelists all know that their full statement is submitted for the record, and just based upon time, and we don't know when the votes are, we won't be mean about the 5 minutes, but we'd like for you to adhere to that as best as possible. So with that, I'm going to turn to the second panel, and first Mr. Thomas Easterly, who's the Commissioner of Indiana Department of Environmental Management. We're very happy to have you here, and so you're recognized for 5 minutes.
Thank you, Chairman Simkus and Ranking Member Tomko and members of the subcommittee. Good morning. My name is Thomas Easterly, and I am the Commissioner of the Indiana Department of Environmental Management, also known as IDEM, and I bring you greetings from Governor Pence of Indiana also. And we appreciate the opportunity to share Indiana's views on the EPA's final Coal Combustion Residuals rule, which we call CCR on occasion. I'm also representing the Environmental Council of the States, which we call ECOS, whose members are the leaders of the state and territorial environmental protection agencies. ECOS has worked on the CCR issue for many years, and our resolution on CCR regulation was first passed in 2008 and has been reaffirmed as recently as 2013. While EPA's final rule responds to some of the concerns outlined in ECOS's resolution, other longtime state concerns remain unaddressed. As an initial point, I express agreement with EPA's finding that coal ash is not a hazardous waste, and that coal ash can be safely and beneficially reused. EPA's use of RCRA Subtitle D for coal ash is consistent with ECOS's resolutions. As a longtime regulator, I have observed firsthand the tragic adverse environmental and human health impacts of CCR surface impoundment failures. These structural engineering failures devastate people's lives, destroy property, and contaminate natural resources. EPA's self-implementing rule contains robust national structural integrity provisions which should result in a meaningful reduction in CCR impoundment failures in the future. The rule also creates a consistent national set of requirements, many of which are already in place in various states, to prevent adverse environmental impacts to our water and air. Units unable to meet the new criteria will have to close, so they will be solving the problem. Most important to IDEM and other states is that EPA's final rule explicitly recognizes the major role state regulatory agencies currently have and should continue to maintain in overseeing CCR. However, by finalizing a self-implementing rule that can only be enforced through citizen suit provisions of RCRA, the role of state regulation, oversight, and enforcement will be significantly marginalized. EPA envisions that the key state role in this program will be maintained by states amending their solid waste management plans to incorporate the new federal requirements. EPA expects that once approved by EPA, the amended plans will receive deference by the courts and citizens. While the requirements of the rule are self-implementing for the regulated units, the rule's schedules would require states to achieve final solid waste management plan amendment with EPA approval on a schedule which cannot be met by many states, including Indiana. In order to ensure transparency, Indiana's laws require my agency, IDEM, to have 4 public notices with associated comment periods for new regulatory action. This public process normally takes at least 18 months, yet some of the self-implementing deadlines in this regulation are as short as 6 months, making it impossible for Indiana to have regulations in place to implement those portions of the rule. Yet, after the state plan is amended and approved by EPA, the new CCR rules will remain independently enforceable through RCRA citizen suits in federal district courts. EPA does not have the legal authority under RCRA Subtitle D to delegate the new rules to the states. I would now like to address the need for a legislative amendment to RCRA on CCR issues. ECOS testified before this committee in April 2013 in support of the bipartisan efforts in the House and Senate to create a federal program that allows states to regulate coal ash management and disposal under a set of federal standards created directly by Congress and implemented by the states. Legislation still would be beneficial in several ways to achieving this goal. First, legislation could codify EPA's determination that coal ash is non-hazardous and get the going back and forth concern done forever. Second, state programs simply cannot operate in place of the federal program without legislation. Third, legislation can add certainty to the process of EPA approving state solid waste management plans by making clear the criteria EPA would apply to determine whether a state program meets the federal CCR standards. And fourth, legislation could enhance and clarify enforcement of CCR requirements. Mr. Chairman, Mr. Ranking Member, and members of the subcommittee, I thank you for the opportunity to present my views and those of ECOS to you today, and I'm happy to answer any questions.
Thank you very much. And I failed to do it, and we'll do it with Mr. Horbeck, but also mentioning that you're representing the Environmental Council of the States, and they've been very helpful in the process. We look forward to working with you. And now recognized for 5 minutes, Mr. Michael Forbeck, Environmental Program Manager from the Pennsylvania Department of Environmental Protection, Bureau of Waste Management, and on behalf of Oswamo. So you're recognized for 5 minutes.
Good morning, Chairman Shimkus and Ranking Member Tonko and members of the subcommittee. My name is Michael Forbeck, and I'm President of the Association of State, Territorial, and Solid Waste Management Officials, OSWAMO, and I'm here on behalf of OSWAMO to testify. OSWAMO is an association representing the waste management and remediation programs of 50 states, 5 territories, and the District of Columbia. Our membership includes state program experts with individual responsibility for the regulation and management of solid and hazardous waste. Thank you for the opportunity to provide testimony on the EPA final rule disposal of coal combustion residuals from electric utilities. The rulemaking has been of a long-standing importance to OSWAMO. We were very pleased to see and are in full agreement with EPA's promulgation of the final rule under Subtitle D of the Resource Conservation Recovery Act. The focus of my testimony is on the issue of dual state and federal regulatory authority we see as a result of the final rule's self-implementing construct. We're not offering testimony on specific technical requirements in the rule, as groups with OSWAMO are looking at these as well as beneficial use components, and we will have additional input on the specific provisions at a later time. EPA has issued the rule under Subtitle D, Part 257, which is self-implementing. The RCRA statutory basis for Part 258, however, governing municipal solid waste landfills, includes requirements for states to develop and implement a permit program to incorporate the federal criteria and for EPA to determine whether those permit programs are adequate to ensure compliance with the criteria. In Oswamo's comments to EPA regarding the 2010 proposed rule, we pointed out that self-implementing standards would set up a dual state and federal regulatory regime for owners and operators that would be problematic for the effective implementation of the requirements of the CCR facilities. Oswamo recommended that a final rule under Part 257 include explicit language that EPA views compliance with a state program that meets or exceeds the federal minimum criteria as compliance with that federal criteria. We appreciate EPA hearing our concerns about dual state and federal regulatory authority and their efforts working within the bounds of their statutory authority to provide a mechanism through the state solid waste management plans to address our concerns. However, we see difficulties with the state plan mechanism, which are as follows. One is timing. In order for states to adopt these minimum standards by amending their solid waste management plans, thereby avoiding dual regulatory authority in theory, the process would have to be completed within 6 months of the date of publication of the final rule in the Federal Register. This is insufficient time since a potential lengthy public participation process involved in the submission of state plans under 40 CFR Part 256 could preclude a timely approval, even if it went smoothly. So there would still be dual state and federal implementation for a time period past 6 months. Solid waste management plans also fall short on full state implementation because even after passage and approval of the plans, as stated in the preamble of the rule, EPA approval of a state solid waste management plan does not mean that the state program operates in lieu of the federal program. Thus, the plans would not fully alleviate dual implementation of state and federal standards. In the preamble, EPA states that the facility that operates in accordance with an approved solid waste management plan will be able to beneficially use that fact in a citizen suit brought to enforce the federal criteria. This is subjective and speculative, as no one with absolute certainty can predict a court's decision. Further, citizen suits filed in different jurisdictions can result in individual courts interpreting the plan and rule differently, thus rendering different decisions that lead to inconsistent implementation of the rule. There is also a concern that more sections of the solid waste management plan than a narrow reopening of the plan to incorporate CCR rule would be reviewed by EPA and potentially require additional revisions to the state plans that may be beyond the scope of CCRs. Oswamo believes that legislation such as H.R. 2218 that was passed by the House in the last Congress would provide for the certainty of state primacy in implementation through state permit programs for CCR enforceable by the state and provide a clearer and consistent understanding of the permitting and enforcement rules of the state. State permit programs of CCR would have the additional benefit of allowing flexibility for states to have regionally appropriate state standards. In conclusion, we appreciate EPA's decision to regulate CCRs under Subtitle D and providing a mechanism which, within the confines of Part 257 for implementation of the rule by the states. However, the revision of the solid waste management plan does not fully eliminate dual implementation of CCR regulatory programs. Oswamo looks forward to working closely with the EPA and Congress regarding the CCR rule implementation. Thank you again for the opportunity to provide this testimony, and I'll be here for questions.
Thank you very much. Next, we would like to recognize Ms. Lisa Johnson, Chief Executive Officer and General Manager of Seminole Electric Cooperative Incorporated. And just for information, I have a lot of cooperatives in my district, and we appreciate the work you all do.
Thank you, Mr. Chairman, and good afternoon. My name is Lisa Johnson, and I am the CEO and General Manager at Seminole Electric Cooperative, headquartered in Tampa, Florida. Seminole is one of the largest not-for-profit generation and transmission cooperatives in the country. Seminole is owned by 9 not-for-profit consumer-owned electric cooperatives, and collectively we provide safe, reliable, competitively priced electricity to more than 1 million consumers and businesses in parts of 42 Florida counties. On behalf of Seminole and the National Rural Electric Cooperative Association, I would like to thank you for your time this morning as I present our testimony on this important issue. Seminole would like to acknowledge that we support the Environmental Protection Agency's decision to designate coal combustion residuals, or CCRs, as non-hazardous. The EPA's approach, supported by data from its own investigations, balances the need to protect public health and the environment without creating an undue burden on affected facilities. Even with a non-hazardous final rule, we are seeking your support to provide additional legislative certainty. Seminole owns and operates Seminole Generating Station, or SGS, a 1,300-megawatt coal-fired power plant in Putnam County, Florida, employing nearly 300 hardworking, skilled Floridians. SGS has more than $530 million of environmental control equipment, making it one of the cleanest coal-based power plants in the U.S. Seminole generates approximately 800,000 tons of CCRs per year. However, Seminole recycles more than two-thirds, or roughly 550,000 tons per year of our CCRs to produce wallboard, cement, and concrete block. At SGS, one CCR material is converted into synthetic gypsum and sold to Continental Building Products. Continental is a wallboard production facility specifically constructed in 2000 to utilize the synthetic gypsum from SGS. Since 2000, more than 7 million tons of this CCR material have been converted into wallboard used to build homes and businesses throughout Florida and the country. Seminole also recycles all of the facility's bottom ash to manufacture cement and stronger, lighter concrete block. If not used beneficially, these byproducts would have been placed in a landfill. In 2009, Seminole received a Sustainable Leadership Award from the Council for Sustainable Florida for our beneficial reuse of CCRs, and SGS was named one of the top 6 coal plants in the world by Power Magazine for our recycling practices and environmental accomplishments. One of Seminole's most important goals is to operate our power plants in a safe, environmentally responsible manner and in full compliance with all permits issued by the Florida Department of Environmental Protection and the EPA, bringing us to one of our concerns with the new rule. While EPA will now regulate CCRs as non-hazardous, the rule is self-implementing, which means facilities covered by the rule must comply with the federal rule regardless of adoption by the state. For example, should Florida adopt the EPA's final rule, the federal rule also remains in place, creating dueling regulatory regimes. As a self-implementing final rule, the typical method for a state or citizen group to check compliance at a facility that may or may not be adhering to the rule is to file suit against the facility. This could result in frivolous and costly legal disputes in federal district courts where the resulting interpretations and penalties could vary significantly. For not-for-profit electric cooperatives, this is especially troublesome, as any costs incurred must be passed on to the consumer owners at the end of the line. We ask that you eliminate the legal double jeopardy aspect of this rule if a state fully adopts the EPA's new final rule. The next major concern we have with the rule is the complete lack of certainty that CCRs will continue to be regulated as non-hazardous. For Seminole, this is extremely problematic, as a major component of SGS design is based on our environmental control systems and our recycling practices. Should EPA decide to regulate CCRs as hazardous at a later time, Seminole would be forced to dispose of CCRs, turning a beneficially used product into an expensive landfilled waste stream, driving up the cost of electricity for our cooperative consumers. On numerous occasions, the EPA has determined that CCRs are not hazardous, and there are no new findings to justify a change in EPA's determination. We ask that you end the continuous reevaluation process and confirm that CCRs are and will continue to be regulated as non-hazardous. For Seminole and other affected facilities, we are seeking regulatory certainty so that we can continue to provide safe, reliable, and affordable electricity while fully complying with all applicable rules, regulations, and laws. On behalf of Seminole and NRECA, I thank you for the opportunity to meet with you today and share our views on this very important rule.
Thank you very much. Now I'd like to turn to Mr. Thomas Adams, Executive Director, American Coal Ash Association. You're recognized for 5 minutes, sir.
Mr. Chairman, my name is Thomas Adams. I am the Executive Director of the American Coal Ash Association. I'd like to thank you for the opportunity to come and speak to you and the subcommittee today about one of America's greatest recycling success stories and how that continued success depends on regulatory certainty. The ACAA was established almost 50 years ago to advance the beneficial use of coal combustion products in ways that are environmentally responsible, technically sound, commercially competitive, and supportive of a sustainable global community. We're not a large trade association. We're not based in Washington, D.C. We're headquartered in Farmington Hills, Michigan, and have a staff of 2 full-time employees. We rely on volunteer members to accomplish our work, which is mostly technical. I'd like to emphasize that while we have some of the largest utilities in the country as members, most of our members are small businesses comprised of people who have dedicated their entire career to the cause of beneficial use in improving our environment. It is these small businesses that were hurt most by the regulatory uncertainty EPA created in 2009 when it suggested the possibility of hazardous waste designation for coal ash management. There are many good reasons to view coal ash as a resource rather than a waste. Using it conserves natural resources, saves energy, and significantly reduces greenhouse gas emissions from the manufacturing of products that it replaces. In many cases, products manufactured with coal ash perform better than products made without it. For example, the American Road and Transportation Builders Association determined that the use of coal ash in concrete roads and bridges saves departments of transportation across the country over $5 billion per year. It's important to remember in this conversation that coal ash has never qualified as hazardous waste based on its toxicity. It does contain trace amounts of metals, and those metals are found at similar levels in soils and hundreds of household items. An ACAA study released in 2012 analyzed data from the U.S. Geological Survey, which showed that concentrations of metals in coal ash, with very few exceptions, are below environmental screening levels for residential soils and are similar to the concentrations found in common dirt. Despite a drumbeat of publicity by anti-coal environmental groups, coal ash is no more toxic than the manufactured materials it replaces. Unfortunately, this discussion has had real-world negative consequences for the beneficial use of coal ash. When EPA began discussing a potential hazardous waste designation for coal ash in 2009, the agency cast a cloud over beneficial use that caused coal ash users across the nation to decrease beneficial use activities. The volume of coal ash used since 2008 has declined every year since that year. The decline in beneficial use stands in stark contrast to previous decades' trend, when in the year 2000, the recycling volume was 32.1 million tons, at the time when the EPA issued its final regulatory determination that the regulation of coal ash management as hazardous waste was not warranted. Over the next 8 years, with EPA encouragement, coal ash beneficial use skyrocketed to 60.6 million tons, and almost a 100% increase in the use. According to the most recently released data from 2013, 51.4 million tons of CCPs were beneficially used, down from 51.9 in 2012 and well below the 2008 peak. The great irony of this lengthy debate over coal ash disposal regulations is that the debate caused more ash to be disposed. If the past 5 years had simply remained equal with 2008's utilization, we would have seen 26.4 million tons less coal ash put into landfills and impoundments. The ACAA appreciates EPA's final decision to regulate coal ash as non-hazardous. We believe this decision puts science ahead of politics and clears the way for the beneficial use of coal ash to begin growing again, thereby keeping millions of tons out of landfills and ponds in the first place. We're also painfully aware, however, that EPA has made final decisions before, only to reverse course in the future. A hazardous versus non-hazardous debate occurred prior to the agency's 2000 final determination, which 8 years later turned out to be not so final. Additionally, the final rule's preamble states that the rule defers final level regulatory determination with respect to CCR that is disposed in landfills and CCR surface impoundments until additional information is available on a number of key technical and policy questions. Apparently, 34 years of study, 2 reports to Congress, 2 formal regulatory determinations, and a final rule issued after a 6-year rulemaking process may not be enough for EPA to make a truly final determination. The bills previously passed by the House would resolve these issues permanently. The bills would put enforcement responsibility authority in the hands of professional state and environmental regulators and expand EPA's authority to step in if states don't do the job. ACAA supports this approach as better public policy. We'd like to thank you, Mr. Chairman, for this committee's diligence in addressing this issue. We believe it's important to keep beneficial use at the forefront of U.S. coal management policy. The best solution to disposal problems is not to dispose.
Thank you very much. Chair now recognizes Mr. James Rower, Executive Director of Utility Solid Waste Activities Group, on behalf of the Edison Electric Institute. Welcome, sir. You got 5 minutes.
Good morning, Chairman Shimkus, Ranking Member Tonko, members of the committee. I am Jim Rower, Executive Director of the Utility Solid Waste Activities Group, or USWAG, and I'm pleased to present this statement on behalf of USWAG, the Edison Electric Institute, and the American Public Power Association. We support EPA's decision to regulate coal ash as a non-hazardous waste, a decision which is consistent with the rulemaking record and with EPA's previous regulatory determinations that coal ash does not warrant regulation as a hazardous waste. Our longstanding position is that EPA should develop a regulatory program for coal ash patterned after the federal regulations in place for municipal solid waste landfills. They would include design standards, location restrictions, dust controls, groundwater monitoring and corrective action, as well as structural stability controls for coal ash surface impoundments. However, while we support EPA's regulation of coal ash as a non-hazardous waste, there are serious flaws in the new rule due to statutory limitations. The problem is that RCRA's Subtitle D program generally does not authorize the implementation of federal rules through state permit programs, nor does it allow EPA enforcement of those rules. The only exception are the provisions under which EPA issued municipal solid waste landfill rules, which are enforceable through state permit programs with backup EPA enforcement authority. USWAG urged EPA to use that authority in issuing this rule, but EPA determined it could not. We're therefore left with a rule that cannot be delegated to states and in which EPA has no enforcement role. Because the rule cannot be delegated to the states, it is self-implementing, and relegated facilities must comply with the rule's requirement irrespective of whether it's adopted by the states. Even if adopted by a state, the federal rule remains in place as an independent set of criteria that must be met. EPA is clear on this point. It cannot, this rule, the state program cannot operate in lieu of a federal program. This will result in dual and potentially inconsistent federal and state requirements. Most troubling, we're hearing that some states might not even attempt to adopt the new rule, which will guarantee dual regulation. In addition, the rule's only compliance mechanism is for a state or citizen group to bring a RCRA citizen suit in federal district court. In fact, we believe this is the only federal environmental law that is implemented in that and enforced in that way. This means legal disputes regarding compliance with any aspect of the rule will be determined on a case-by-case basis by different federal district courts around the country. Federal judges will be making complex technical decisions regarding regulatory compliance instead of allowing these issues to be resolved by regulatory agencies that have the technical expertise and experience necessary to answer such questions. This is likely to produce differing and inconsistent decisions regarding the scope and applicability of the rule, depending on where a citizen suit is brought, and will undermine the uniform application of the rule. This is not a sound strategy for implementing a complex federal environmental program that has such significant implications for the power generation industry. Because the rule is self-implementing, EPA dropped risk-based options for implementing elements of the groundwater monitoring program and for conducting cleanups, reasoning that such risk-based decisions require regulatory oversight. As a result, the federal rule effectively overrides existing state risk-based regulatory programs for coal ash that have been proven protective of human health and the environment. Some of our members are in the middle of implementing long-term site-specific closures or cleanups for coal ash facilities. We're concerned that the federal rule's lack of recognition of state risk-based closure or cleanup programs may effectively negate these efforts. The rule also regulates inactive impoundments no longer receiving coal ash but which contain water and have not closed. We fully appreciate such inactive sites may pose risks, and steps should be taken to address those risks. However, we do not believe EPA has the authority to subject past disposal practices to regulations designed for active units, as the agency has done in this rule. Congress has authorized EPA to address risks from past disposal under Superfund and by issuing site-specific remedial orders if past disposal poses an imminent and substantial endangerment. If EPA wants additional authority, we believe the statute must be amended to grant EPA such authority. Finally, the rule does not provide the desired certainty that coal ash will not be regulated as a hazardous waste. EPA makes clear that it will at some point in the future issue a new regulatory determination regarding whether coal ash warrants hazardous waste regulation. While EPA has for now settled on the non-hazardous waste option, the agency leaves the door open to revising the rules and regulating coal ash as a hazardous waste. This raises serious concerns. Companies across the country will be investing huge resources to come into compliance with the new rule, even as EPA contemplates establishing a whole new regulatory program that could effectively negate these huge capital expenditures. We need regulatory certainty regarding the status of coal ash under RCRA. This rule does not provide that. I'd like to thank the subcommittee for the opportunity to present these views, and would be happy to answer any questions.
Thank you very much. Chair now recognizes Mr. Eric Schaefer, Director of Environmental Integrity Projects. Sir, you're recognized for 5 minutes. And I think you should hit a button that's on your mic.
Thank you for the opportunity to testify. I am Eric Schaefer, Director of the Environmental Integrity Project. We've worked with citizens who live and work around coal ash sites, and as certainty seems to be the theme for the hearing, I'd like to speak to what certainty might mean to those good people. some of whom have been living with this problem for a very long time. First, I really don't think folks in these communities care whether you call it hazardous or whether you call it peanut butter. They want coal ash out of their groundwater. They don't want it in their lungs. And they would rather not have 39 million tons of it dumped in their river, as Duke Energy did to the good people of North Carolina less than a year ago. We hear that those kinds of problems are things of the past. They aren't going to happen again. I'll return to that, but obviously they did happen. So really the question is whether EPA's rule or anything Congress does gives people most affected by coal ash pollution the kind of certainty they're looking for. I just want to point out that this issue's been bumped around for about 30 years. In that time, a lot of these disposal sites, which are nothing more than holes in the ground, have deteriorated. The cost of responding to spills and the resulting contamination from just 6 companies now exceeds $10 billion. That's based on Securities and Exchange Commission disclosures. That number is going to climb whatever happens. 30 years of no regulation, a bill comes with that, and that bill is coming due. Touching briefly on the rule, like everybody here, we like some parts, we don't like others. Not too unusual for an EPA outcome. The siting and structural stability requirements could be helpful and could prevent the kind of catastrophic spills we've seen. Monitoring requirements are a good start, especially if the data is put online and you don't have to pay hundreds of dollars to obtain it, which you do in many states today. I do have to say, though, it has some big loopholes. There's no cleanup standard for boron. That's one of the most pervasive pollutants, and it's found at levels far above health standards at many coal ash sites. Also, it's important to understand nobody's going to get windburn complying with the deadlines in EPA's rule, some of which stretch literally from here to eternity. This is not a fast-paced set of standards, and I encourage you to look at those deadlines. Before moving forward, I would respectfully ask that you consider 2 things, 2 actions. First, I think you should invite Duke Energy to appear before this subcommittee to talk about the spill that happened less than a year ago, because it's important to get an understanding of the problem before turning to the solution. You can then, with that information, decide whether EPA has addressed the problem. Here's what Duke said in 2009. We are confident, based on our ongoing monitoring, maintenance, and inspections, that each of our ash basins has the structural integrity necessary to protect the environment. So if you called in Duke Energy, you could ask them about Dan River, because a statement was made about Dan River. So what the heck happened? Is it going to happen again? Are you certain it's not going to happen again? And how are you certain? North Carolina passed a law in the wake of that spill that requires shutdown of active ash impoundments at active plants in less than 4 years, a lot faster than EPA requires. Duke Energy supported that bill. You might ask them why they supported it and why those requirements wouldn't apply in a place like Indiana, where Duke also has plants. That's certainty. They have to close by date certain. Couldn't be clearer. I would also hope that you'd consider giving citizens who are affected by the coal ash pollution a chance to speak to you directly, without interpreters, without lobbyists. I'd gladly give my seat up so you could hear from them. I'm sure Jim would do the same thing. You could hear from them directly about what it's been like and ask them what kind of certainty they're looking for. I think you'll hear they'd like the certainty that leaking dumps will be closed and cleaned up sometime in their lifetime. I think you'll hear that. Many of them have been waiting a long time. I think they'll want the certainty they won't get stuck with a bill for that cleanup. They'd like the certainty that their ash pond is not going to collapse and fall on top of them and dump ash into the river. I think they'd like the certainty they can bring their own legal action if the state doesn't do anything. I think you'll hear that, but let them tell you directly. I just say in closing, these citizens have worked on these issues for a long time. They really do deserve to be heard from. I hope you'll give them that chance. Thank you, Mr. Chairman.
Thank you very much. And last, and you all have done a great job, we've gotten through the opening statements. Last but not least, Mr. Holman, Senior Attorney for the Southern Environmental Law Center. Sir, welcome, and you have 5 minutes.
Thank you, Mr. Chairman, and thank you, Mr. Tonko and other members.
And I think there should be.
How about that? Does that work?
I think so.
Good.
Well, thank you, Mr. Chairman, and Mr. Tonko and other members of the committee for the opportunity to be here. My name is Frank Holloman, and I live in Greenville, South Carolina. I am at the Southern Environmental Law Center, and we work with local citizens in the South concerned about their natural resources. A committee like this in Washington usually hears from representatives of government agencies and trade associations. Today, I want to convey to you all the concerns of local people who want to see their communities prosper and their local rivers protected. Let's look for a minute what we're facing in the Southeast. The utilities have dug unlined pits in wetlands and right beside our drinking water resources. They have put millions of tons of industrial waste containing toxics like arsenic and lead into these unlined pits, and they have filled them full of water. These millions of wet tons of waste are contained only by earthen dikes that leak. The toxic substances in this industrial waste leach into the groundwater, which then flows into the rivers and towards neighborhoods. This situation is made worse because most of these pits are decades old and their infrastructure is rotting. We have had 2 catastrophic failures from this coal ash storage in the South, by TVA at Kingston, Tennessee, and by Duke Energy in the Dan River in North Carolina and Virginia. One local water system is being forced to abandon public drinking water wells. Fish have been killed in the hundreds of thousands. Property values of nearby landowners have been affected, and groundwater has been contaminated with substances like arsenic. My main point is this today. The Congress should not take away the rights of local communities to protect themselves from this dangerous coal ash storage. The Congress should not leave the future of these people to government bureaucracies alone. The citizens' right to enforce a new EPA rule is essential. Now, what we have seen in the Southeast is clear. The state agencies have not effectively enforced the law against these politically powerful entities. Let me give you examples. In South Carolina, where I've spent virtually all of my life, it has been clear for years that unlined coal ash storage by our 3 utilities violate anti-pollution laws. Yet no government agency had taken action to force a cleanup. Local organizations instead enforce the law, with the result today that all 3 utilities in our state are cleaning up every water-filled riverfront coal ash lagoon they operate in the state. And they are creating jobs. They're promoting recycling, and one of our utilities calls these cleanups a win-win for all concerned. In North Carolina, nothing was happening to force Duke Energy, which has a statewide monopoly, to clean up its coal ash lagoons. Local community organizations, not the state, had to take the initiative to enforce clean water laws. For the first time, North Carolina was forced to take action and confirmed under oath that Duke Energy is violating state or federal clean water laws, or both, everywhere it stores coal ash in the state, and under oath that this polluting storage is a serious threat to the public health, safety, and welfare. Now, a federal criminal grand jury is investigating both Duke Energy and the State Environmental Agency. And as a result, Duke has pledged to clean up 4 of its 14 sites and to look at all the rest. In Tennessee, TVA continues after Kingston to store coal ash in unlined polluting pits. Local citizens groups enforce the Clean Water Act, and only in response to that pressure, the state of Tennessee has now confirmed under oath that TVA has been and is violating Tennessee environmental laws by its coal ash storage on the Cumberland River near Nashville. In the South, we have seen that the people must have the power to protect themselves and to enforce the law. The citizens' right to enforce a new EPA rule is a principal reason to have hope that these minimum federal criteria will play a role in cleaning up a legacy of dangerous coal ash storage in our Southeast. Thank you.
Thank you, sir. I'll now recognize myself for 5 minutes for the first round of questioning. First question for Ms. Johnson. How would your company make compliance decisions if the Florida Department of Environmental Protection sets requirements that are not exactly the same, even if they are more stringent than the final rule?
Thank you, Mr. Chairman. It would be a challenge. Clearly, we would have to comply with both sets of rules and whatever the requirements would be. If one was more stringent than the other, we would look to comply with the stringent rule, except in this case, we would know that there would be the potential of having both regulatory regimes competing with each other for our compliance. Not to mention the fact that I think that makes us vulnerable as an operator of a facility to third-party lawsuits that may question which actual regulation is the leading one. So it would be very challenging.
And for Mr. Rower, in the final rule, because it is, quote-unquote, self-implementing, EPA eliminated much of the flexibility of corrective action program as exists under other Subtitle D programs. Could you please walk us through what flexibilities were eliminated and what that would mean for closure and corrective action?
Yeah, thank you. There are a few instances where the agency had contemplating a different approach to allow for potentially a risk-based decision to establish a point of compliance, to establish an alternative groundwater protection standard. For unlined units, to even engage in corrective action and not have to shut down summarily. The agency recognized that the regulatory oversight from a regulatory agency wouldn't be there under a self-implementing rule. Regulatory oversight to ensure that that risk-based decision-making is appropriately applied, and backed away from that, and instead we're faced with the self-implementing rules. So they take away a lot of the tools that state regulatory agencies have in prescribing cleanups and prescribing corrective actions.
Yeah, and go back and briefly explain this risk-based decision-making, what it is and how it may be incorporated into a state coal ash program.
Well, a state could take into account whether there is a receptor down gradient from the facility. You're seeing a release, but is it in fact presenting a risk to human health and the environment? And they can take that into account when they're making a decision about whether corrective action is needed or what type of corrective measures must be implemented by the utility.
In your opinion, would EPA be able to approve a state program that incorporated any of the flexibility for corrective action, including a risk-based decision-making process?
The rule is rather clear about what you have to achieve in corrective action. You must meet that standard. If you don't meet that standard, you can't. So I'd have to answer no. I couldn't see how EPA could say that a state program that incorporates that sort of risk-based decision-making is the equivalent of the federal rule.
Thank you. Mr. Forbeck, as an experienced state regulator yourself, and I presume you have spoken with your counterparts in other states, can you share your initial thoughts on the final rule, in particular the implementation?
Well, as I testify, we have a real issue with the implementation because we feel it still would be a dual process. And it would be very confusing for the states. They have to decide whether or not, one, they're going to even open up their solid waste management plan. And even if they do, will that really even alleviate the dual regulatory regime? We do not think it will.
Yeah, and who testified in their opening statement, because we got a big panel, about the 6 months required under the EPA? That was yours.
Right.
And then some states might take 18 months to do their solid waste plan based upon the laws in the states about hearings and notifications and the like.
That's correct. The issue is that it's not just a simple fix that we open up the plan and it's approved. It's a public participation process, which is fine, but that will take some extra time.
And finally, my last question is for Mr. Easterly. Your written testimony states that the opening and approval of the state solid waste management plan must be completed on an aggressive schedule that Indiana cannot meet. Can you explain why that is and whether you expect that would be a problem other states might have as well? And tell Governor Pence hi for us.
Okay. Yes, other states will have that problem. Some states may or may not have the right authority. Some states, the rules have to go through the legislature before they can actually go into effect. In my state, I have to publish a first notice with a 30-day comment period that I'm going to do a rule, a second notice with the words of the rule in it with another 30-day comment period. Then I have to publish a notice of a hearing in front of the Environmental Rules Board for preliminary adoption, then one for final adoption. Then the Attorney General gets days to review it, the Governor gets days to review it, and the Secretary of State publishes it. And it takes 18 months.
And I thought we were bad. So now the chair now recognizes the gentleman from New York, Mr. Tonko, for 5 minutes.
Thank you, Mr. Chair, and welcome, everyone. Unsafe disposal of coal ash poses very serious risks to human health and to the environment. The number of damage cases cited by EPA in the final rule is more than ample proof that current regulation isn't working for many communities. In 2009, this subcommittee held a hearing on damage from coal ash disposal. We heard from victims who lost their homes, their businesses, and their health to coal ash contamination. In the time since that hearing, problems have continued. Hopefully, the implementation of this rule will reduce these events and their costs going forward. For today, I would like to focus on a recent high-profile damage case and what it can teach us about compliance and about enforcement. Mr. Holloman, can you tell us a little bit about the Dan River spill?
Yes, Mr. Tonko, it has been a real tragedy, and how it happened illustrates how state enforcement and utility oversight by itself has not worked. And let me tell you why I say that. The basic cause is the Dan River site is an old site, like virtually everyone in North Carolina. You have these old pits. And somebody in the course of constructing that site had the bright idea of putting a stormwater pipe under one of these coal ash lagoons. Back in the 1980s, Buke had received in its own files, and the state had this, a dam safety report warning them about this problem of having a corrugated metal pipe under a coal ash lagoon. And in subsequent reports, there were constant references to be sure you check this pipe, be sure you check this pipe, be sure you watch what's coming out of this pipe. Well, instead, this old site, which unfortunately was built right on the banks of the Dan River, which is true of most all these facilities are right on the banks of rivers, right upstream from a drinking water source. That pipe on Super Bowl Sunday a year ago broke, corroded, finally gave way, and spewed coal ash and also 24 million gallons of coal ash polluted water into the Dan River. Subsequently, Duke says it's done all it can do, and it has removed less than 10% of the ash from that river, thereby declaring defeat. In other words, once one of these spills occurs, they cannot clean it up. Now, why were we even in a position that this should happen? Because we were engaging in the foolhardy practice of storing this industrial waste in a riverside lagoon filled with water, held back by earth, that the earth and dikes with rotting infrastructure. Had that ash, as is happening in South Carolina today as we speak, had that ash instead been stored in a dry state, in a lined landfill, like we require for simple municipal garbage, away from the river, this would never have happened. In other words, these sites are engineered or not engineered to be as dangerous as possible. The shocking thing is the Dan River site is the smallest coal ash site that Duke has in the state of North Carolina. In that sense, in some odd way, we were fortunate.
Thank you. We've heard from other witnesses on your panel that states are best positioned to enforce coal ash disposal requirements. Do you think states have proven their ability to effectively enforce coal ash rules?
Well, just take the Dan River, for example. The state had never required a cleanup. In fact, believe it or not, 6 months before the spill, in response to a notice the citizens sent, the state was forced to file a lawsuit. 6 months beforehand, it stated in writing in a public filing under oath that Duke was violating state and federal clean water laws at that site, and that if those things were not corrected, it was a serious threat to public health, safety, and welfare. And not one thing was done in the ensuing 6 months to get the ash moved out of that site. That's one illustration.
Mr. Schaefer, do you agree with that assessment?
I do. We've had similar experiences in Pennsylvania.
Yeah, turn the microphone on, please. I'm sorry.
I'm sorry. They felt like they weren't getting a response from the state in response to their repeated complaints. We filed notice of intent on their behalf to bring a suit. The state turned around, decided the site presented an imminent and substantial endangerment, required its closure, and required, we think, a pretty aggressive cleanup, and the state did credit citizens for getting that result.
Thank you.
Gentleman's time expired. Chair now recognizes Mr. Harper from Mississippi.
Thank you, Mr. Chairman. I'm going to yield my time to the gentleman from West Virginia, Mr. McKinley.
Thank you, Mr. Harper. I appreciate that. Whole host of subjects here with this panel that we have before us, and one of them, one of the issues that has been dear to us in the Panhandle of West Virginia has been the Little Blue Run. We've not had, Mr. Schaefer, despite your comments, we had the havens here. We've had people that have experienced that. We want to hear that. We want to make sure that we're sensitive to that. And so this panel, this committee has done that, and maybe should continue to do that even more. But they were here to testify about what those situations were like, and I thought it was a very moving testimony for their part. But Little Blue Run is even now under your group, Mr. Homan. I guess the Environmental Integrity Project, or is that yours, or that's yours? Okay. You put out a report that calls in harm's way lack of federal coal ash regulations endanger Americans and their environment, and that was given to the Pennsylvania because they're the ones primarily responsible for the Little Blue Run, and they did a very exhaustive study because they want to respond. You know, these allegations of people, these threats that come out, and they came back and they said, based on the review of the information in this report for this particular facility, DEP of Pennsylvania concludes that the allegations regarding groundwater and surface water contamination are unfounded. So I want us to be careful that we can come here and make these testify to these. There are adequate responses and there are recourses for it, and DEP looked into it. I have pursued this because I think it is. We need to be careful about that. I've been in touch with Pennsylvania about how they monitored Little Blue, in West Virginia as well, and we see that they've levied fines. They have indeed done what they said they were going to do, and that was to enforce the law and the requirements with it. So I think that it appears to me from their reports and their letters and their correspondence, they're trying to be good stewards of the environment, and they are enforcing that. So I'm curious. We passed legislation in the 112th, 113th that dealt with the existing and future impoundments, line, unline, addressing those issues. We included in that language, because I've heard you say it several times here, about the siting restrictions are in that language. But didn't your group oppose the bill? Either one of you?
We certainly did and would continue to do that. The siting restrictions in that legislation, we don't think were comparable to the
But okay, if I could recover my time, the reason that I raise these issues to you is that if I could recover my time, please, on it,
okay,
is that if we don't pass the legislation, then we stay the way we've been since the 60s, and that hasn't worked. That's what's caused a lot of these issues. We're trying to find a way to get a resolution, and we're trying to find a solution. Here was a bill. If we have to tweak it, but to defeat it, as they did over in the Senate, that wasn't productive. We had a bill. We're going to do it again this year, and we're going to see it again. I hope that people that have some concerns about work with us, because we've got to reach certainty. I heard all the testimony. We've got to find a way to close the door so the people that are making the investment in their respective facilities know that tomorrow they'll be able to continue to operate. So it's very important that we pass the legislation to close up these loopholes, close up some of the issues that have defined this and made it a negative. So with that, I thank you for your testimony. I hope that you will continue to work with us, all of you, the entire panel, as we perfect this if we need to go even further with it. So with that, I yield back the balance of my time.
Gentleman yields back his time. Without objection, I'm asking unanimous consent to allow Mr. Schaefer to respond for a minute to
Thank you.
and we kind of abide by rules. Mr. McKinley gets another 5 more minutes, so we're going to let you interject here before he goes next again.
I very much appreciate that, Mr. Chairman. I'll be quick. It really is useful to compare what Pennsylvania said in its complaint in 2012 about the condition of that site to what they told EPA the condition of that site was during the rulemaking process. It's really kind of different. You'll see very different statements. You'll see the states saying the site's leaked. You'll see them saying the company has, their practices present an imminent and substantial endangerment to the environment. You don't see any of that coming through in the testimony to EPA. The enforcement action the state took, and I just don't want this point to get lost, came after the citizens filed a notice of their intent to sue the company for those violations. Not before. It came after. Now, Pennsylvania, if they would like to tell you they were going to do it anyway, I'd be happy to hear that. That's great, but we didn't get that feeling.
Yeah, fortunately, you've got 17 seconds left. We'll allow Mr. Forbeck from the great state, the Commonwealth of Pennsylvania, to respond.
Yes, actually, I'm very familiar with the little bit run this is for me for Pennsylvania. I actually signed a consent decree going through the procedures to close this facility. We actually had been looking at that site long before that the suit was filed. And as anything, that's what's the beauty of the system that we have in place, is that we have groundwater monitoring, we have air monitoring, we have all these factors that are in place that we're constantly looking at a facility. We're constantly looking at the compliance of that, and therefore it's a moving target. At one point, it may be one thing, at another, in the future, it may be another. But we have those monitoring points in place that can tell that. So yes, we've actually had started enforcement procedures before that, and because of this and the issues that we found, they are actually closing the largest coal combustion impoundment in the United States in an environmentally safe manner.
Thank you very much. Now, because of the magic of our rules, the chair recognizes the gentleman from West Virginia. Are you done? Okay, thank you. Chair now recognizes the gentleman from North Dakota, Mr. Kramer, for 5 minutes.
Thank you, Mr. Chairman, and thank you all of the panelists. I want to get to one very specific point. To me, it's obvious that the patchwork, the inconsistency potential, the uncertainty that would be created by self-implementation and enforcement by courts, that's a problem. That's a problem for me on lots of fronts. But I would like at least the 2 regulators to speak to the issue of, if we were to tighten that up, put state primacy in place as it is in so many areas like this, and codify, codify the language in the EPA and certainly the definition of non-hazardous. Do the citizens of your states or any of our states lose their ability to appeal, to attend hearings, to complain? I mean, it's sort of like we're talking about either citizens have rights or the bureaucracy has rights, and the 2 can't go hand in hand. Because as a former regulator myself, frankly, we heard more from citizens in these hearings than we heard from any other person. To me, the local and state level is where you get more citizen interaction, not less. So could somebody elaborate on that for me? And then if there's time left, I certainly would welcome you as well to comment on that.
As far as SWAMO and our members, we feel that we're all in favor of minimum federal standards. We feel that the codification of it and the certainty of it is the key point that was missing in all this. No, we do not think that citizens will lose their ability to have public forum or further appealing of decisions. No, we feel that will continue.
And the thing that would help by having a federal law, and certainly the EPA rules will help, is that there are a number of states, luckily not including my own, where it is not allowed to have a more stringent regulation than the federal government. So having this federal rule and then having a law that says you must do this, I think will help a lot, so that those states will have this program implemented at the state level. And you're right, at the state level, we have people on the ground in the field for the citizens to talk to, and they certainly can come, in our case, to Indianapolis, and they have legislators out there, and they do have a lot of input.
So, Mr. Schaefer, Mr. Holman, same question, because this is a concern to me, frankly,
Right.
what you raised. I just want to ensure that what we're doing would not in any way negate citizens' access.
Is my microphone on? Yeah, it's a good question, but we're really talking about two entirely different things. Citizens have the right under federal and state statutes to comment on, to be present at hearings, as you saw as a state commissioner, in determining whether a permit is put in place or what regulation is adopted. That's true. That's not what we're talking about. We're talking about once your commission or in our state environmental commissions put in place a permit or regulation, and then the utility violates it. After the public has had input, they just violate it. They don't comply. And then the state agency, for whatever reason, which we have seen repeatedly, refuses to enforce the very permits, laws, and regulations that have been produced through this public comment period. So it makes it pointless. You go comment, you go through this process, which is important, as you say, but then the very state government that put this in place refuses to enforce what the citizens participated in creating. In fact, in our state, our Public Service Commission, which held hearings on this topic, one of the commissioners expressed shock that Duke had not yet moved its ash from one of the sites that was present there and was not complying with the permit and regs that our state regulatory agency had put in place.
So did this shocked commissioner have any opportunity to do something about it? In other words,
he did not.
You have state legislators, I assume they're elected, governors are elected. In the case of North Dakota, the Public Service Commission is elected. So I'm just seeing it, these things, including enforcement, being closer to the people, seems to me to be better for the people than removing it from the people.
Well, no, it is in the hands of the people. The people who are taking this enforcement action are local community people going to their local state or local federal courthouse. These are people who live next door to you and me. These are people in the community. They have to be.
But I don't see this law or this principle being violating that.
As long as you all don't fool with or mess with the citizens' right to sue under RCRA, we still have that right to sue. And the citizens have the right to go forward and see that the law is enforced. But if you were to affect that, you are taking rights away from the people and saying they belong only to a bureaucracy which may or may not act.
And the gentleman's time's expired. And I just want to assure people that there's no discussion, neither in the last bill, of alleviating or taking the citizens' right to sue out of RCRA. So you could rest comfortably in that. Votes have been called. We still have one member who wants to ask some questions. So, Chair, turns to Mr. Latta for 5 minutes.
I'll be brief, but again, thanks for our panel and your patience, especially we have a different series of votes today. If I could just kind of go down the line real quick with a few of you. You know, there's been quite a good discussion here today as to the implementation, the uncertainty as to certain things that have to be done. I'm just kind of curious, starting with Mr. Easterly. How much input did you have with the EPA when they were implementing the rule?
They're not implementing it yet, but when they
when they were formulating,
we sent in comments. Certainly through ECOS, we had a number of discussions with them of what we would like to see, and some of it's in, and some of it's not.
Okay. When you say some of it's in and some of it's out, what percentage would that be? Give us just kind of a ballpark.
Well, we like that it's Subtitle D. We, along with other people, are disappointed at the way it's being implemented.
Okay. Mr. Forback?
Well, as SWAMA, we share the very similar feelings. We were involved heavily with the correspondence and comments to EPA about the rule, and as was said, we do appreciate B&D. It is the implementation under the Salt Waste Management Plan that was our concern. It does not have certainty that we wanted to see.
Okay. Just switching gears real quick, question again that I'd asked the administrator before he finished up his testimony today on the certainty, especially on the beneficial use. Ms. Johnson, especially with you in your testimony, especially with the company that is really located near you to make the board, do you think there's certainty out there right now? And do you think that there could be changes in the future from the EPA?
I believe, based on what EPA has stated, that they clearly have the opportunity to revisit their determination on non-hazardous versus hazardous for CCRs, and that creates uncertainty. And I will tell you in my experience that for the beneficial use community, for our plant that provides a significant portion of our CCRs to the beneficial use community, that uncertainty is a problem. And a later designation or determination of hazardous is going to put that beneficial use process at risk.
Mr. Adams?
I think in terms of the effect on the market so far, it's too early to tell if there's been a positive effect. We have heard many comments that people are happy that EPA has gone with Subtitle D, but it's troubling to have that language in the preamble that they may want to go back and revisit the bevel exemption. Again, they said it in '93, they said it in the year 2000, they've now said it again that coal ash didn't warrant hazardous waste management, but then they come back and say, well, we might need to revisit it again. We need action by Congress to put an end to that chain of events.
Mr. Eastler, how about you on the whole issue of the beneficial use and the certainty?
I personally don't think it's certain when you say that you're going to reopen it. In history, EPA has changed, for example, the maximum contaminant levels in drinking water, which since the hazardous waste leachate test is 100 times that standard, suddenly makes something that used to be non-hazardous into hazardous. And I think that can change at any time in the future, and all businesses have to assess that risk and what could happen to them.
And just a little off topic, Mr. Easley, since I border Indiana, I have about halfway down. What's Indiana's percentage of coal for your electricity?
It's going down, but I think it's still over 85%. It might be over 90%.
Okay, because I remember it used to be around 90%, and Ohio, especially up my area, is around 73%. And with that, Mr. Chairman, in the interest of time, I yield back.
I thank the gentleman, and before I adjourn, I need to ask unanimous consent to accept a letter by the Prairie River Network, located in Champaign, Illinois, and accompanying attachments from local communities and resolutions. Without objection, so ordered. And we want to thank you all for coming. A great hearing. Look forward to working with you as we move forward. And this hearing is adjourned.
Good to see you, yeah.
Right, nice meeting you.